네, 감사합니다. 이제 4세션을 시작하도록 하겠습니다. 4세션의 주제는 금지명령의 주요 쟁점으로서 금지명령의 요건, 기준, 내용, 범위, 집행방법 등에 대해서 다룰 예정입니다. 진행은 우성엽 특허법원 고법판사님께서 맡아주시겠습니다. 큰 박수 부탁드립니다.
네, 안녕하십니까. 오늘 4세션의 사회를 맡게 된 특허법원의 우성엽 판사입니다. 오늘 1세션부터 3세션까지 많은 세션을 들으시느라고 많은 고생을 하셨고요. 드디어 마지막 세션에 이르렀습니다. 조금만 힘을 내시면 행복한 저녁 만찬이 기다리고 있습니다. 저희 세션은 특허권 침해로 인한 금지명령의 다양한 쟁점에 관해 세계 최고의 전문가분들과 함께 논의한 자리를 갖게 되었습니다. 저는 개인적으로 매우 기쁘고 영광스럽게 생각합니다. 세션 시작에 앞서서 4세션 패널분들께 깊이 감사드린다는 말씀을 드리고 싶습니다. 그럼 4세션에 참여하시는 패널분들을 패밀리 네임의 알파벳 순서에 따라 소개해 드리겠습니다. 자세한 양력은 자료집을 참고하시고 큰 박수로 맞이해 주시면 감사하겠습니다. 우선 제 옆에 에드먼드 챙 미국 일리노이 북부 연방지방법원 연방판사님입니다. 그 옆에 리차드 헤이컨 영국 지식재산기업법원 부장판사님입니다. 그 옆에 앉아 계시는 안나-레나 클라인 독일 뮌헨 제1지방법원 판사님입니다. 그 옆자리에 요시아키 시바타 일본 도쿄 지방재판소 부장판사님입니다. 한국에서는 두 분이 패널로 참가하십니다. 먼저 이경은 춘천지방법원 부장판사님입니다. 이어서 권보원 특허법원 판사님입니다. 세션 진행 중에는 통일적으로 판사님으로만 호칭하겠습니다. 그리고 본 세션을 시작하기에 앞서서 특허법상의 금지명령에 관한 간단한 배경 말씀을 드리겠습니다. 금지명령은 특허권 침해로 인한 권리자 보호에 있어서 손해배상과 더불어 가장 중요하고 강력한 구제수단입니다. 대륙법계 국가법원에서는 특허 침해 소송에서 침해 사실이 인정되면 특별한 사정이 없는 한 원칙적으로 침해 금지 명령을 발령하는 것이 주류적인 실무였다고 보입니다. 이와 관련하여 미국에서는 지난 2006년 미국 연방대법원의 이베이 판결 이후 전통적인 형평법상의 4가지 요건 기준에 따라서 금지명령의 발령 여부가 정해지고 있다고 보이고, 독일에서는 지난 2021년 특허법 개정으로 금지명령 조항의 비례성 요건이 새로 도입되었습니다. 이 세션에서는 특허권자의 권리를 효과적으로 보호하되 그 권리 범위를 넘는 과도한 보호가 되지 않도록 하기 위하여 금지명령의 여러 쟁점에 관해서 각국의 입법례와 실무에 관해서 논의해보고자 합니다. 본 세션은 2개의 파트로 구성되어 있습니다. 여기 슬라이드에 보시는 바와 같이 먼저 각국의 특허법상 영구적 금지명령과 임시적 금지명령의 발령 요건과 기준을 먼저 비교해보고, 이어서 2번째 주제로 각국의 금지명령의 내용과 범위 그리고 그 집행방법에 관해서 논의를 해보겠습니다. 이번 세션의 주제에 대해서 패널분들께서 사전에 자세한 답변을 보내주셨고 그 내용은 자료집에 잘 정리되어 있습니다. 이를 참고해 주시면 감사하겠습니다. 시간의 제약으로 인해서 세부 질문들을 통합해서 질문과 답변을 하고 패널분들에게 충분한 시간을 드리지 못하는 점에 대해서 미리 양해의 말씀을 구하겠습니다. 자, 패널분들께는 패밀리 네임의 알파벳 순서에 따라서 답변 요청을 드리겠습니다. 아까 소개해드린 바와 같이 미국의 챙 판사님, 영국의 헤이컨 판사님, 독일의 클라인 판사님, 일본의 시바타 판사님, 그리고 한국 패널분들 순서입니다. 패널분들께서는 주어진 시간 내에 답변을 맞춰주시면 감사하겠습니다. 첫 번째 주제는 금지명령의 발령 요건과 기준에 관한 것입니다. 첫 번째 공통 질문으로 금지명령의 원고 적격에 관한 간단한 논의부터 해보겠습니다. 예, 질문입니다. 귀국에서는 특허권자가 침해 금지 청구를 하려면 직접 또는 최소한 실시권자를 통해서 해당 실시권을 실시하고 있을 것이 요구되는지, 아니면 특허권자의 특허권 실시 여부는 침해 금지 청구 요건과 무관한지에 관해서 설명을 부탁드립니다. 답변은 1분 이내에 해주시기 바랍니다. 자, 먼저 미국의 최행 판사님 발표 부탁드리겠습니다.
No. No, thank you, Judge Wu, for moderating and organizing us so well. But yeah, the general answer is no. To the Supreme Court, of course, held in eBay versus Merck exchange that there is no general requirement that the patentee practice the patent in order to obtain an injunction. And in fact, the Supreme Court emphasized that broad absolute rules, like you must practice a patent, is inconsistent with our traditional equitable principles. And that, as President Grabinski mentioned, when we issue injunctions, we sit in equity. And that is very much a case-by-case evaluation. So a broad rule like practicing a patent is inconsistent with that. With regard to licensing activity, the Supreme Court has not recently addressed this issue, but the eBay case did cite, with approval, a case from 1908. It had to do with paper bag folding, a patent on paper bag folding. And that patentee did not practice the patent at all. He did not license the practice at all, the patent at all, and he was still able to obtain an injunction. So I suspect that if it were to reach the Supreme Court, even licensing activities would not be required. Thank you.
예, 최행 판사님 감사합니다. 그러면 이어서 영국의 헤이컨 판사님 답변 부탁드립니다.
Well, like Judge Chang, I can easily answer this in 1 minute. Again, the answer is no. The statute, the Patents Act 1977, gives the patentee a right to appropriate relief if its patent has been infringed, and that will always include an injunction irrespective of whether it's been practicing the invention or not, or even licensing the invention. It's a right if you win your patent trial.
예, 답변 감사합니다. 이번에는 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. Well, my short answer would be no, but. So a slightly different comparison than my colleagues from the US and England. So our section 139 of the Patent Act, which deals with injunctions, only relates to the aggrieved party, without differentiating between this party actually practicing the patent or not practicing the patent. However, like you mentioned, we did have an amendment back in 21, and this fact that the plaintiff is an NPE could actually be one factor to consider when assessing proportionality issues. However, we will look at a decision tomorrow of my court actually. The courts, after the amendment entered into force, did take the position that the plaintiff being an NPE, as such as the single circumstance, is not enough to show disproportionality. And I guess this is in line with, how we view patents, because if you want a patent to be a transferable good, then it follows that you should not focus on the fact that the plaintiff is an NPE. Thank you.
예, 답변 감사합니다. 그러면 이어서 일본의 시바타 판사님 답변 부탁드립니다.
Thank you all, and I'm very honored to be here. Yes, the answer is no. Yes, in Japan, the patent right is considered to have so-called inclusivity. So, in principle, injunctions are granted if there is infringement or likely to infringement. That's a simple answer. But as Judge Klein said, NPE may be one factor, but I said after this. That's the answer.
예, 시바타 판사님 답변 감사합니다. 이어서 한국의 권보원 판사님 답변 부탁드립니다.
To follow the established precedent by Judge Chang, I would say no. Article 126 of Korean Patent Act states that a patentee or an exclusive licensee may seek an injunction against a person who infringes or is likely to infringe their rights. It's similar to Japanese Patent Act. They must be registered at the point of the trial level's closure to get an injunction, but practicing is not a requirement. However, I think it kind of aligns with a German Patent Act amendment. If a patent is not being practiced, it can still influence decisions on preliminary injunctions or damages calculations.
예, 답변 감사합니다. 예, 이상의 발표에서 대다수의 국가에서는 특허권자의 실시 여부가 침해 금지 청구의 요건에 해당하지 않는다는 사실을 알 수 있었고, 예, 다른 하나의 고려 요소로 고려될 수 있다는 점을 알 수 있었습니다. 예, 그러면 이어서 공통질문 1-2로 넘어가겠습니다. 공통질문 1-2는 영구적 금지명령에 관한 것입니다. 시간 관계상 공통질문 2-1의 세부 질문을 통합해서 질문을 드리겠습니다. 먼저 귀국의 특허법상 영구적 금지명령에 관한 법 규정의 내용과 발령 요건 및 판단 기준에 관해서 설명을 부탁드리고, 만일 금지명령의 발령 요건으로 특허권 침해 사실 외에 추가적인 요건을 고려하는 국가들의 경우에는 그와 같은 추가적인 요건의 구체적인 내용은 무엇인지, 추가적인 요건의 증명 책임은 누가 부담하는지, 그 증명의 정도는 어떠한지에 관해서 설명을 부탁드립니다. 그리고 혹시 귀국에서 피고의 특허권 침해 사실은 인정되었으나 추가 요건을 고려하여 침해 금지 명령이 발령되지 않는 판결 사례가 있으면 소개해 주시면 감사하겠습니다. 답변은 세부 질문을 통합하여 3분 이내에 해주시기 바랍니다. 예, 이번에도 먼저 미국의 최행 판사님께 발표를 부탁드리겠습니다.
Thank you. In eBay, the Supreme Court decided that the traditional equitable requirements for the issuance of a permanent injunction apply to patent cases just like any other case. So this was an example of the Supreme Court, which is a generalist court, refusing to create special rules for patent cases. And so what that means is that beyond infringement, the patent owner must show the traditional 4 elements, which is that they would suffer an irreparable injury, that remedies at law, usually money, would not be adequate compensation. The court must balance the hardships between the plaintiff and the defendant for issuing the injunction, which is the proportionality I think others have spoken about. And then the 4th element is to weigh the public interest. And so the plaintiff must show all 4. And it is the plaintiff who bears the burden of proof by a preponderance of the evidence to obtain a permanent injunction. And just a couple of examples, and there's some more details of this in the written submissions, where the plaintiff, the patent owner, otherwise established infringement but still was not able to obtain a permanent injunction. There was a case in which the patent issue dealt with microscopic fluid droplets, and one of the defendant was a very small company, and the patent owner was a very large company. And the defendant, the infringer, because the company was found to be infringing, sold 2 product lines that the company was basically entirely dependent on. And there, the Federal Circuit Court of Appeals held that there should not be an injunction issued there. The reasonable royalty would be enough, because otherwise the small company might cease to exist entirely. So that's one example. And then another example is a situation where the patent owner sells to one segment of the market and the defendant, the infringer, sells to another segment of the market. And there too, the Federal Circuit has approved the refusal to issue a permanent injunction where there is not an overlap in competition. And instead a royalty would be sufficient. So there are times when the patent owner, despite showing infringement, is not able to obtain a permanent injunction.
예, 최행 판사님 답변 감사드립니다. 그럼 이어서 영국의 헤이컨 판사님 답변 부탁드리겠습니다.
Both proportionality and public interest can be taken into account when the court is considering whether to grant a final injunction. But courts have been rather specific about what those two things mean. Proportionality means, is an injunction proportionate to the potential damage to the patentee if there is no injunction? So if, for example, the patentee has stopped infringing, hardly infringed at all, or as Judge Chang said, if they're in different market sectors, the court might consider that an injunction just is not proportionate to the potential damage suffered by the patentee, so no injunction. But they are very rare cases. Much more common, although still quite rare, are public interest cases, where the court says, well, the injunction would potentially damage the public interest. And I can give you an example. In fact, it was an example that Klaus Grabinski mentioned this morning that was in the English court. There was a patent action, actually it came before me, to do with a heart valve. And I found that the patent was valid, it was infringed, and therefore, in principle, subject to public interest. The patentee was entitled to an injunction. But I was told at the hearing after the trial, well, there are some patients who can only use this kind of valve, and there's a potential risk to their lives if you grant an injunction. And in fact, I said, well, you can't just turn up and say this. I need evidence. You need to come back, and this needs to be reviewed in more detail. When it did come back, I actually went to another judge because I was doing something else. But what the judge said is, yes, there is a potential risk to the health of this small cohort of patients who could only use this specific valve that the defendants sold and infringed. So what the judge did, he said, I will grant the injunction, but there will be an exception for 12 months. For 12 months, the defendant can continue to sell this valve to purchasers who will use it only on this particular kind of patient. And in fact, he went further. He said, within that 12 months, the patentee can come back and say, well, people have been trained up to use another valve now, and so they would then cut the exception short, so it would be shorter than 12 months. Equally, the defendant could come back and say, we're getting close to 12 months, we still have the same problem, we want an extension. So it was left flexible, but that was a public interest point because there was a risk to life. It was a case called Edwards and E-Valve Sciences. That's the kind of case where, fairly unusually, the court would refuse to grant a final injunction.
예, 헤이컨 판사님 답변 감사드립니다. 이어서 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. So, like you said earlier, we had this amendment in 21, and we will look at the wording in the next question, I guess, of our sentence that has been introduced concerning this proportionality test in section 139, subsection 1. Now, what I would like to stress is this proportionality test really relates to exceptional cases, and the injunction remains the absolute rule. It's not comparable to the eBay factors or anything. And this is not only my view, although I do share this view, but it's the legislator's view as well. If you look into the memoranda accompanying the bill, the draft bill, you will find that the legislator really had those extreme cases in mind. And also the courts who had to rely on this disproportionality test after the amendment came into force, took the stance that you have to look at exceptional cases. So really, I would rather say that this is not an additional requirement, it's not a proportionality requirement, but rather it's a disproportionality defense. This also means that the plaintiff does not have to in their statement of claim, address proportionality. They do not have to show that the injunction is proportionate or the request for injunction is proportionate. Only once the defendant raises the issue of proportionality to show disproportionality, then the plaintiff has to react. And only in those cases will the court look into proportionality issues as well. We will look into some details, the factors that can be considered tomorrow in our case study session. But it's really, this is the most important thing, it's a disproportionality defense. This also means concerning burden of proof. If the facts that are, well, could lead to disproportionality are debated between the parties, it means that the defendant has to prove those facts. So really, it's on the defendant to show disproportionality. We did not have a successful disproportionality defense in Germany until now. I went back to this question 2 days ago. I did not find a case. I don't know of any case. I did not find a published case. So I think there's simply none. And although that's the fact, I would like to briefly agree with Judge HACON what the possible consequences of a, well, successful defense would be. It's not that we would totally exclude the injunction, but in most cases, we would rather limit the injunction, for instance, in a time-wise manner. So we would give a transition period or great use-by period, so much like the Hardwolf case that you mentioned. Only in very exceptional cases, so the exception amongst the exceptions, will the injunction be totally excluded. But that's really a super seldom case. Thank you.
예, 답변 감사합니다. 예, 그러면 이어서 1번에 예, 시바타 판사님 답변 부탁드리겠습니다.
Article 100, paragraph 1 of the Japanese Patent Act provides that the patentee may file a claim against a person that infringes or is likely to infringe that patent right or exclusive license for the cessation or prevention of the infringement. So, to grant a permanent injunction, the law requires the infringement or likeliness to infringement and doesn't require the establishment of additional elements. But in Japan, when the execution of the right to seek an injunction is considered to be an abuse of right, an injunction will not be granted. The abuse of right defense is an affirmative defense. So the defendant bears the burden of proof of this defense. There is much discussion. So when deciding whether the execution of the injunction is abuse of right or not, consideration may be given to relevant factors such as degree of contribution of the patent right to the finished product as a whole, the amount of damages caused to the patentee due to infringement, the possibility of recovery in claims for damages, the magnitude of disadvantage caused to the infringer by the injunction, public interest, etc. So, but in Japan, much discussion has been made about the factors of abuse of right defense. And the defendants sometimes assert this defense. But so far, there has been no court precedent in which the abuse of right defense in a narrow sense has been successful. So I think it's very exceptional defense, but we discussed this defense much. Thank you.
예, 답변 감사합니다. 이어서 한국의 권보원 판사님 예, 답변 부탁드립니다.
As I mentioned earlier, and as Judge Shibata explained about Japanese law and practice, Korean Patent Act also only requires an infringement or the likelihood of infringement for an injunction. So to speak, the law does not impose additional requirements like public interest or proportionality. However, defendants can still argue abuse of rights, similar to Japan, under the general principles of the Civil Act. For instance, seeking an injunction might be deemed to be an abuse of rights if the patented invention lacks novelty or an inventive step. I'd like to introduce to you an interesting case recently rendered by one of the chambers in Administrative Division of the Seoul High Court on August 30th, 2023. The court found that the plaintiff of pharmaceutical company seeking a preliminary injunction against generic drug producers, knowing that the drug did not infringe upon its patent and fully aware that its own patent was registered based on fabricated bioequivalence test data was an unfair exercise and abuse of patent rights. It was an administrative law case, so the result was to affirm a corrective order and a penalty surcharge by the Fair Trade Commission. Interestingly, the court explicitly mentioned its reference to two decisions of the U.S. Supreme Court. One was Professional Real Estate Investors versus Columbia Pictures Industries, and the other was Walker Process Equipment versus Food Machinery and Chemical Corporation. I feel like Korean judges are open to adopting well-reasoned foreign jurisprudence. I hope Korean courts' well-reasoned precedents can also be translated well and exported to other countries to promote our harmonization of IP laws. So to sum up, while the law does not expressly stipulate additional criteria such as public interest or proportionality, Korean court managed to strike a balance between safeguarding patent rights and fostering a fair and competitive market landscape, eventually to promote innovation. Thank you.
예, 판사님 답변 감사합니다. 예, 그러면 이어서 최근 개정된 독일법에 관해서 독일의 클라인 판사님에 대해서 개별적인 질문을 드리겠습니다. 이미 이전 질문에 대한 답변에서 많은 소개를 해주셨던 것 같습니다만 독일의 2021년 특허법 개정 이후에 침해 금지 명령의 발령 요건이나 증명 책임 등에 관해서 독일 법원의 실무에 어떠한 변화가 있었는지, 그 다음에 특허 침해가 인정되었으나 비례성 등의 요건을 고려해서 침해 금지 명령을 발령하지 아니한 판결 사례가 있었는지, 그리고 특허법 개정 이후에 침해 금지 명령이 발령되는 사건과 발령되지 않는 사건의 비율에 변화가 있었는지에 관해서 설명을 부탁드리겠습니다. 답변 시간은 2분 이내에 해주시기를 부탁드립니다.
So some of these questions I've already answered. If this defense is raised, obviously we will consider it very carefully. I would say it's an additional defense that's been brought to us in most SEP cases after the amendment entered into force. Not every SEP case, but like at least 80% of the SEP cases. So it's an additional defense that the defendants obviously will use. It's been not successful until now, and so I can't say that really there's been a change in granting injunctions. But what we did see is that some courts, especially Düsseldorf and Munich, we concerned ourselves with the relation between this new proportionality defense or disproportionality defense and the defenses that had been known until then. For instance, Düsseldorf had to decide concerning the relation between the possibility to get a compulsory license on the one hand, so these would be third parties or maybe a Hardwolf case, and the disproportionality defense on the other hand. And they ruled that the disproportionality defense was subsidiary. And the same was found concerning the friend defense and the disproportionality defense. We will go back to that tomorrow again in the case of the Regional Court of Munich 1. And we held that if a defendant is found to be an unwilling licensee under the friend defense, most probably his disproportionality defense will not be successful either. There have been other cases as well, most concerning the chance or the possibility to find a workaround. So where the defendant already has a workaround, or where he should have found a workaround by now because he did have enough time in an NEP case, also the court said, well, in those cases you can't rely on the disproportionality defense. So really the granting practice has not changed, but obviously there has been much case law, and in most SEP cases we do concern ourselves with proportionality issues nowadays.
예, 답변 감사합니다. 예, 한국에서도 독일의 특허법 개정 내용에 관해 많은 관심이 있었는데 독일의 특허법 개정 이후에 침해 금지 명령에 관한 독일 법원의 실무 관행과 변화에 관해서 잘 설명해 주셔서 감사합니다. 예, 그러면 다음으로 공통 질문 1-3으로 넘어가도록 하겠습니다. 이번에는 각국의 예비적 또는 임시적 금지 명령에 관한 실무에 관해서 논의를 해보겠습니다. 예, 귀국에서 도입하고 있는 예비적 또는 임시적 금지 명령 제도를 소개해 주시고 영구적 금지 명령과 비교하여 발용 요건이나 증명의 정도에 있어서 어떠한 차이가 있는지 또 절차적으로는 본안과 별개로 신청할 수 있는지에 대해서 설명을 부탁드립니다. 개인적으로 답변 주신 것을 본 결과 미국은 조금 그 스탠다드가 좀 높은 것 같았고 다른 나라들은 그 본안의 영구적 금지 명령 요건에 비해서 조금 낮은 정도의 증명과 을 요구했던 것 같습니다. 그런 부분에 좀 관심을 가지고 답변을 들으시면 많은 도움이 될 것 같습니다. 그러면 먼저 미국의 최행 판사님 답변 부탁드리겠습니다.
Thank you. Yeah, in the United States, there are two forms of provisional relief: temporary restraining orders and preliminary injunctions, and this is governed by Federal Rule of Civil Procedure 65. For temporary restraining orders, those are issued without notice to the other side. They are ex parte. And the rule requires that the plaintiff show that they would clearly be irreparably injured if notice was given to the other side. And so they need the TRO immediately. And I always tell lawyers that if you ask for a true TRO, where I'm going to issue an order without giving the other side an opportunity to respond at all, then your client's hair should be on fire. I mean, it really should be very rare that I simply cannot get at least some, even a verbal response from the other side. Temporary restraining orders, because they are so extraordinary, they are initially valid only for 14 calendar days. They cannot extend initially beyond 14. As that 14th day approaches, if the plaintiff can show that the TRO is still justified, that they are still suffering or would suffer irreparable injury, they can ask for one extension of another 14 days. So a temporary restraining order can last at most 28 days. They are not appealable. Right? Either the grant or the denial of a temporary restraining order is not appealable. So this is a very important proceeding in the district court. Preliminary injunctions, on the other hand, of course you have given notice to the other side, and indeed, very often in patent cases, I will allow some very limited and very fast discovery, where the other side I will authorize a limited number of document requests and depositions and interrogatories. So preliminary injunctions, they're still expedited, but the other side does have notice and an opportunity to respond. In terms of the burden of proof, the standard of proof for provisional relief, such as a temporary restraining order or preliminary injunction, is that the plaintiff must make a clear showing of entitlement to relief. So this is a higher burden of proof than receiving a permanent injunction. And that's because, at least in the United States, we consider these to be extraordinary remedies. We have not made the final decision. We have not had all the discovery we typically engage in. And so the plaintiff must make a clear showing. And then the motion is independent of the merits proceeding. This will be, we'll decide the temporary restraining order and the preliminary injunction, the provisional relief, and then down the road we will have the jury trial and decide the merits. The rules of civil procedure do allow the court to consolidate, right, to bring the preliminary injunction proceeding together with a trial and even with a jury. Whenever I ask, the parties always say no. They do not want to consolidate with the merits proceeding. And I think for most American lawyers and American clients, they want the full discovery before they reach the trial stage.
예, 답변 감사합니다. 이어서 영국의 헤이콘 판사님, 예, 답변 부탁드리겠습니다.
In English procedural law, we call these interim injunctions. And we also have the distinction between an ex parte injunction, which is applied for by a party without the defendant being present, and the more regular interim injunction, which is after a hearing from both sides. Ex parte injunctions are very unusual. One, because it goes against the grain of basic justice to have an injunction granted against somebody who hasn't had the right to turn up and explain their side of the case. But if it's extremely urgent and it's very obvious that the claimant is going to suffer damage, then ex parte injunctions are possible. There are severe sanctions, well, there are sanctions against a party who obtains ex parte relief on evidence which is either misleading, which is very unusual, but evidence which is incomplete, which is more usual. So if the claimant has been careful about how much they show the judge, and that emerges later, then certainly the injunction will be discharged and there could be other sanctions. Otherwise, the more common injunction is the one that lasts between the hearing and the trial. And to get that kind of injunction, the claimant has to show three things. One, that there's a serious question to be tried. They have some kind of case. It's not a very high hurdle to overcome. Secondly, that they have the money to compensate the defendant if they are to lose a trial. And thirdly, that they're going to suffer irreparable harm between now and the trial if there's no injunction. What it means is harm that can't be compensated in money if they were to win a trial. So, for example, if they were to lose the right of monopolizing a particular market because the defendant were to enter into that market, that may be irreparable harm that could never be compensated. So if those three criteria are satisfied, the judge then considers whether the defendant would suffer irreparable harm if there is an injunction. And if it would, the judge tries to strike a balance between those two. If the balance is equal, then and only then is the judge entitled to look at the likely outcome at trial. But we really try and avoid that result because otherwise it turns into a mini trial before the trial. But if the balance favors the claimant, then the injunction will be granted.
예, 답변 감사합니다. 이번에는 독일의 클라인 판사님 답변 부탁드리겠습니다.
So in Germany, we do have provisional or preliminary injunctions, and they can be granted ex parte, but this is only very seldomly done, much like Dr. Grabinski mentioned earlier. So to get in a preliminary injunction, we need to show an infringement on all the other things that you need to show under Section 139 of the Patent Act. And then you have some additional procedural requirements. You need to show that there's some kind of reason for the provisional injunction. So you must need to show urgency, and you must need to show that a certain balance of the interests of the parties tips in favor of the plaintiff. Now, as it requires level of proof, it might be different because in a provisional proceeding, it might be enough to just show prima facie evidence, and for permanent injunction, you must need full proof. But I would like to stress that, at my court at least, the threshold is quite high. Like I said, we very seldomly issue ex parte injunctions, maybe if there's a trade fair issue, but usually we at least have a written procedure between the parties, and in most cases we will have a hearing. And those hearings last for hours, like days, and so we really get into all the matters. We go into claim construction, we look at the attacked embodiment, and obviously in most cases we discuss validity issues. So really this is, what we do is a very fast mini patent infringement case. So the threshold is quite high. You don't have to have a merits proceeding to get a provisional injunction. This can be filed totally independently. And in many cases, we only have a provisional injunction, and there's never a merits case.
예, 답변 감사합니다. 그럼 이어서 일본의 시바타 판사님 발표를 부탁드리겠습니다.
We have preliminary injunction in Japan. So Article 23, Paragraph 2 of the Civil Provisional Remedies Act provides that preliminary injunction. The requirement for a preliminary injunction are likeness to infringement on the merits and the necessity or to preserve the right holder's position pending the final determination. So we need the necessity to preserve the right holder's position pending the final determination. The proof required for a preliminary injunction is a prima facie case. So, like German case. So, prima facie showing shall be made using evidence that can be examined immediately. So, only usually documentary evidence is used. A court will accept prima facie evidence that is above factual fact. The proof required in the permanent injunction on the merit is certainty beyond a reasonable doubt. So the level of proof in the preliminary injunction is maybe lower, but it's very high. And it's possible to file a separate injunction for a separate motion for a preliminary injunction independent of the merit proceedings. It's like German.
예, 답변 감사드립니다. 그럼 이어서 한국의 권보원 판사님 발표를 부탁드립니다.
In Korea, preliminary injunctions can be categorized into two, one concerning the object of dispute and the other to establish a provisional position, with the latter being the type used against patent infringement. As in other countries, ex parte injunction is very seldomly, rarely granted. Although provisional, it restrains the defendant from practicing the invention, just as a permanent injunction would, on the merits would. The issuance of a preliminary injunction requires proof of rights to be preserved and the necessity or need for preservation. Rights to be preserved in this case would be infringement or the likelihood of infringement. Preliminary injunctions demand a high level of the necessity for preservation due to the potentially severe impact on a defendant's business. It is evaluated based on various factors, including the anticipated merits decision, the likelihood of who would win, and the severity of damages the patentee may endure due to infringement, and factors like defendant's ability to compensate or whether the infringement was willful, potential impact on public welfare or national defense, the defendant's effort to avoid infringement, and the broader business context, such as a defendant's market share or business stage, can also be considered. To sum up, the court has, I would say, comparatively bigger discretion when it comes to granting a preliminary injunction. Preliminary injunctions are often granted with the condition that the petitioner provides security to cover potential damages incurred by the defendant due to the enforcement of the injunction. However, if subsequent rulings invalidate the patent or find there was no infringement, the injunction would be cancelled and the plaintiff would possibly be liable for the defendant's damages. Thank you.
예, 답변 감사합니다. 예, 지금까지 살펴본 첫 번째 주제는 각국의 본안에서의 금지명령과 예비적, 임시적 금지명령의 실체법적, 절차법적 차이에 관한 비교를 해볼 수 있는 좋은 기회였던 것 같습니다. 이로써 첫 번째 침해 금지 명령의 발령 요건과 기준에 관한 제1주제를 마치고 침해 금지 명령의 집행에 관한 제2주제로 넘어가도록 하겠습니다. 제2주제는 각국의 침해 금지 명령의 내용과 범위 그리고 소송 절차에서 피고 제품 또는 피고 행위 특정에 관한 것입니다. 공통질문 2-1에 관한 것입니다. 공통질문 2-1도 세부 질문을 통합해서 진행하겠습니다. 먼저 귀국에서 금지명령의 형식과 내용 및 범위 등에 관해서 정하고 있는 법이나 규정, 판례 등이 있으면 설명해 주시고 침해금지 청구 시에 구체적인 피고의 실시 제품이나 피고의 실시 행위를 특정을 해야 하는지 아니면 피고는 원고의 특정한 특허권을 침해 행위를 해서는 안 된다라는 형식의 광범위한 내용의 금지명령도 허용되는지 여부를 알려주시고 만일 피고의 제품을 특정을 해야 한다고 하면 구체적으로 어느 정도까지 특정을 해야 하는지에 관해서도 설명을 해주시고, 그리고 마지막으로 귀국에서 실무상 허용되거나 허용되지 않는 금지명령에 구체적인 기재례가 있다면 소개를 해주시면 감사하겠습니다. 답변은 세부 질문들을 통합해서 3분 이내로 해주시면 감사하겠습니다. 먼저 미국의 치행 판사님 발표 부탁드립니다.
Thank you. In American law, there are actually very few statutes and rules that direct federal judges to explain their decisions. Of course, by judicial craftsmanship, and because we want to maintain our credibility with the bar and the public at large, and we also want to ensure that whoever does not prevail understands that we consider their arguments. We, of course, explain our decisions as much as we can, but there are actually very few statutes and rules that require us to do it. At sentencings, we do have to explain our decisions, that there is a statute that requires that. Temporary restraining orders and preliminary injunctions, that is one of the rare instances in which a rule explicitly directs federal judges to explain the reasons for its issuance. And the rule also goes on to say that we must state the injunction terms specifically and also in reasonable detail. We have to describe the acts that are subject to the injunction. And this specificity does arise from the fact that if someone violates a temporary restraining order or permanent injunction, we can find them in contempt of court. And I think there's another question that might deal with that, so I'll put that off for a moment. But it's a very serious step to find someone in contempt. So we do have to, under both the rule and the Federal Circuit precedent, we do have to specify the accused product and what is not permitted. And so in this international rectifier case decided by the Federal Circuit, this is just one example of an instance where the district court entered an injunction that was too broad, at least in part, because the injunction said that any device covered by one or more of claims 1 through 5 of the patent, you must not distribute that kind of device. Well, that's too broad. That just says do not infringe the patent. That is not a specific enough act in order to support an injunction in American law. The only, and I wouldn't even say this is an exception, this is the only additional point I think that is important is that the injunction does apply to a product that is not more than colorably different. Right? That's the term that the courts use, not more than colorably different than the accused product. So for example, if I have issued an injunction against a microphone array, right, an invention that has a microphone array, and the infringer reduces the number of microphones in the array from 12 to 11, and then they try to sell that as a different product, that is not more than colorably different, and so that would still be subject to the injunction even though it's not the exact same product, right? But that's the only difference. So we do need to specify the product.
예, 답변 감사합니다. 그러면 이어서 영국의 헤이컨 판사님 답변 부탁드리겠습니다.
Well, the statute doesn't say anything about the form a final injunction should take. And until about 22, 23 years ago, this was a subject of some debate in English courts as to whether the injunction at the end of a patent trial should be specific or should be general. And then there was a judgment of the Court of Appeal which said it should be general. And broadly, because the Court of Appeal thought that it causes more problems than it solves to grant a specific injunction. So how does this work? Well, it usually arises, for example, if the patentee comes back after the trial and is seeking damages, and let's suppose the trial was all about the defendant's Model X infringing, and the judge has decided Model X infringes. And then the patentee comes back and says, oh, well, the defendant is selling Model Y as well. we want damages for that. Well, it will depend in large part on what the judgment, the reasoning in the judgment said. If the judgment said, well, features A, B, and C in your product taken together mean the product infringes, and A, B, and C are all found in Model Y as well, then an injunction, the judge will rule that the generally phrased injunction not to infringe patent number, whatever it is, will cover Model Y. Or if feature C is trivially changed, as Judge Chang, in the manner Judge Chang was talking about. So it crops up then, or sometimes it crops up when there's a question of enforcement. The patentee comes back and says they are in breach of your broad order because they're selling Model Y. The same question would arise. Or very occasionally, the patentee comes back and says, we want a declaration from the court to make it clear that not just Model X, but also Model Y, perhaps Model Z, are also included in the injunction. And then the judge at that stage will clarify exactly to which products the injunction applies. But in the first instance, it's always generally phrased that the defendant is restrained from infringing patent number, whatever it is.
예, 답변 감사합니다. 그러면 이어서 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. So the injunction order is part of our decision. It's part of the operative part of the tenor. And like we learned, both Germany and Korea obviously put this in front of the decision. So the reasons for the injunction must be set out in the injunction decision. And still, you must see that the injunction order should be understandable on its own terms. So just by looking at the operative part, somebody should understand what this entails, because this is so very decisive for the parties, much like Judge Chang just said. However, the operative part may refer to attachments, for instance, to photos, and in cases of doubt, it may also be interpreted. Now, do we allow broad injunctions? It depends on when you ask me. Some years back, when I first started out in patent law, I was told that we should always try to specify the attacked embodiment as specifically as possible. And this goes back to Federal Court of Justice's decisions stating that we should always try, even in the first instance, we should always try to be as specific as possible. And I will cite one of those examples in my presentation. At the same time, back then we did have a lot of mechanical issues. Nowadays we do have a lot of mobile phone things. And so it's very hard to describe a mobile phone. You can give a photo of a mobile phone in a tenor, but this won't help you in any way. So nowadays we actually allow the parties to only cite the claims in suit, and also we, in our tenors, we usually only use the claims in suit. If in some decisions it's necessary to really specify the attacked embodiment, then you can use photos, you can use a literal explanation of the attacked embodiment. It's very important to stress this, the court will not go beyond the prayers of the parties. So in most cases, especially in SAP cases, the plaintiff will refer to the attacked embodiments and state that with this claim, they really want to attack all the products of the defendant that use a certain standard. So it's a very broad attack. And if there's reason to give this injunction, we will follow suit with the wording of our injunction. But there are cases where the plaintiff limits themselves, for instance, to a certain phone model. And so in those cases, obviously, we will not go beyond the scope of the plaintiff's prayers. So if you see different versions of tenors, this might always depend on the prayers that we get from the plaintiffs. Thank you.
예, 답변 감사합니다. 그러면 이어서 일본의 시바타 판사님 발표를 부탁드리겠습니다.
So there's no provisions about this issue, but in Japan it is so that target product and specific conduct that is subject of the injunction should be specified in the injunction. Broad injunction without identifying the accused product or conduct of the defendant are not allowed in Japan. In terms of the effectiveness of injunctions, injunctions must specify the target product and the target act, we think. So in the scope of what is prohibited, if the scope of what is prohibited is not clear, the defendant cannot know what action is prohibited. Furthermore, when carrying out compulsory enforcement, it must be clear which acts violate the injunction. Whether or not the target product is specified, generally speaking, depends on whether or not it is possible to distinguish the target product from other products according to the social norm. But in Japan, it is common Japanese court practice that the target product is specified by the product name or model number if the target product has a product name. So maybe just the name has changed model X to model Y. So what happens? So but we think that the patentee will petition for a preliminary injunction against the product with a new name. And preliminary injunction would be issued quickly if it is proven that the product is not different from the origin. So we think that this court practice is reasonable. Thank you.
예, 시바타 판사님 답변 감사드립니다. 그러면 이어서 한국의 이경은 판사님 답변 부탁드리겠습니다.
네, 금지명령의 내용과 특정의 정도에 관해서는 한국에서도 그동안 상당히 논란이 있었던 것 같습니다. 그런데 하지만 지금은 어느 정도 이제 실무의 태도가 정리된 것 같고요. 그래서 저는 제 발표 내용은 이제 그런 정리된 현재의 실무 태도를 기준으로 하겠습니다. 특허 침해 금지 명령에 관해서 가장 기본이 되는 규정은 앞서 언급된 특허법 제126조입니다. 그리고 금지를 구하는 피고의 행위는 피고의 침해 형태, 즉 특허권의 실시 형태에 따라서 구체적으로 특정이 되어야 됩니다. 특허법이 제2조 3호에서 실시에 해당하는 구체적 행위를 규정하고 있어서 이 규정에 해당하는 행위로 금지 대상 행위가 특정되게 됩니다. 뭐 예를 들어서 물건의 발명인 경우에는 그 물건을 생산, 사용, 양도, 대여 또는 수입 등을 하는 그런 구체적인 행위가 되게 됩니다. 그리고 제품 및 방법의 특정 정도에 관해서 대법원 판례는 그런 민사소송 청구 취지 특정의 일반 원칙에 따라서 사회통념상 다른 것과 구별될 수 있을 정도로 구체적으로 특정될 것을 요구하고 있고 서울고등법원 판결에서는 이것을 좀 더 구체화해서 침해 여부의 판단 및 집행 대상의 식별에 지장이 없도록 구체적으로 특정되어야 된다라고 한 바 있습니다. 이런 판시들은 이제 금지 대상이 피고가 현재 침해하거나 침해하려는 행위이기 때문에 원고가 이제 청구 취지에서 피고가 실제 침해하거나 침해하는 행위 그리고 그 제품이나 방법을 구체적 개별적으로 명확하게 집행 가능하게 특정해야 한다는 것을 의미하고요. 금지명령 역시 이에 따라 발령이 되게 됩니다. 그래서 이런 관점에서 한국에서는 피고는 원고의 특허권을 침해해서는 안 된다는 형태의 금지명령은 발령하지 않고 있는 것으로 알고 있고요. 그다음에 특허권의 특징적인 구성 요소를 기술하고 이를 구비한 피고 제품이라는 형식의 금지명령 역시 발령하지 않고 있습니다. 이런 금지명령들은 그런 법률상의 추상적이고 일반적인 금지 의무를 기재한 것과 다름이 없어서 기판력의 범위가 확정되지 않고 집행 단계에서도 특허권 침해 여부에 대한 추가적 판단을 필요로 하기 때문입니다. 그러니까 기판력의 범위와 집행 가능성이 가장 중요한 기준이라고 보시면 됩니다. 그래서 특정의 모습을 좀 더 구체적으로 말씀드리자면 피고 제품이 제품명이나 모델명, 제품 사진 등으로 특정되면 좋고 그렇지 않더라도 집행기관 식별에 지장이 없도록 도면이나 제품 구성에 대한 설명으로 명확하게 특정이 되면 됩니다. 방법 발명 같은 경우에는 피고가 사용하고 있는 구체적인 방법 또는 제조 공정을 기재함으로써 그 방법을 특정하게 됩니다. 그리고 제가 특별히 아주 넓거나 아주 좁은 수준의 금지명령 사례는 찾기 어려웠지만 침해 제품을 제품명과 구성, 형상으로 특정한 다음에 여기에 더해서 제품명을 달리하지만 구성 형상은 동일한 제품을 그 금지 폐기 대상으로 할 수 있는지에 관해서 서로 다른 입장을 취한 두 개의 판결이 있어서 소개합니다. 여기 PPT 화면에 나오는 그런 사진과 사안을 참고해서 같이 보시면 좋겠는데요. 먼저 서울중앙지방법원의 582904 판결입니다. 화장품 용기에 관한 그 특허 발명 침해가 문제된 사안인데요. 금지 대상을 피고가 실제 실시하고 있는 제품과 제품명 사진 뿐만 아니라 이제 각 구성에 대한 설명까지도 덧붙여서 특정을 했습니다. 원고는 이제 여기에 대해서 실제 실시하는 제품과 동일한 구조와 형상을 가진 다른 명칭의 제품들도 포함해서 금지를 구하였는데 이 판결에서는 그 부분, 다른 명칭을 가진 제품들 부분은 집행 가능성이 부족해서 특정되지 않았다고 판단하였습니다. 반면에 다른 입장을 취한 두 번째 판결이 있는데요. 571828 판결입니다. 이 판결 같은 경우에는 금지 및 폐기 대상 제품을 특정한 그런 특정된 제품명에 한정하지 않고 특정 구성을 갖춘 경우까지 포함하여 인정하였습니다. 뭐 개인적 의견으로는 두 번째 태도 정도가 적절하지 않은가 생각하고 있습니다. 감사합니다.
예, 답변 감사드립니다. 예, 그러면 이어서 공통질문 2-2로 넘어가도록 하겠습니다. 예, 이 질문은 만일 피고 제품 중의 일부 구성이나 일부 부품만이 특허권 침해에 해당되는 경우에 금지 명령의 범위에 관한 귀국의 실무와 판단 기준을 소개해 주시기 바랍니다. 답변은 1분 이내로 해주시기 바랍니다. 먼저 미국의 챈 판사님 발표 부탁드립니다.
Yeah, generally speaking, a patent owner must show that the infringement causes the harm that is targeted by the injunction. When there is a device with multiple components and only one component infringes the patent, then the courts say that there must be a causal nexus between the infringing acts and the harm. And I'm sure all the interpreters paused on causal nexus quite understandably because it is a very legalistic term. What the Federal Circuit has explained further is that all that means is that there must be some connection, right? Some connection between the patent features and the demand for the infringing product. Right? The patent owner does not need to show that the infringing component is the exclusive or even the dominant reason why consumers demand the product. And I think that is an outgrowth of the idea that in a multi-component product, very often consumers are deciding based on their purchasing decision based on many of the components. And so it would be too difficult for a patent owner to show that the infringing component was the exclusive or predominant reason for the purchase. So just some connection is needed.
예, 미국 챈 판사님 답변 감사드립니다. 이어서 영국의 헤이컨 판사님 답변 부탁드리겠습니다.
Well, if the patent only covers a small component in a large product, then selling the large product will still infringe the patent. So, in principle, the injunction will stop the sale of the large product. It's possible that here an argument on proportionality could arise. The defendant could say, oh, well, your patent is only for a new clever kind of screw, and we've used only one in our huge product, and if the court grants an injunction, we're losing profits on the whole product, whereas we're only infringing just this little screw part. That could be a reason for considering whether to make an award of damages instead of an injunction, but I've never heard of such a case. And I think the reason I've never heard of such a case in English law is because on the facts you can always replace this clever new screw with a slightly less clever old screw or whatever it happens to be. And in truth what the defendant is saying is that by infringing we're making our product a bit more competitive because we're using this component. And the answer is, well, you can't. The injunction would stop you. So the answer is to go back to using slightly older technology, which may mean your product is a bit less competitive, but that's the consequence of infringing. So I've never heard of a proportionality case that covers that, but in principle it could.
예, 답변 감사드립니다. 예, 그러면 이어서 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. I agree with Judge HACON, and basically on yes, if an injunction may address the whole product, even if only a very smallish part in this complex product is infringing the patent, and obviously complexity of the product might be a proportionality factor to consider. I actually remember a case as a judge rapporteur, and it's the one case where of the tenors that we just saw, where we did use a photo, so you can always go back to those materials and find the case if you're interested, where actually it was about a very small-ish valve in a car, and this car, well, and there we had the discussion of proportionality even before the amendment entered into force. But also in this case, we did not find for disproportionality. Now, concerning the second part of the question, manufacturing equipment, this may be destroyed if it's predominantly used for manufacturing infringing products. So really there must be at least 50% of usage for these infringing products. And there's a special disproportionality test concerning this destruction. So an additional proportionality issue, at least. Thank you.
예, 예, 답변 감사합니다. 그러면 이어서 일본의 시바타 판사님 발표 부탁드리겠습니다.
Yes, the same as two countries. So, as I said, in most cases in Japan, the target product is specified by the target model name or brand name. Product was specified by the product name. As long as the object is specified as one product, the injunction shall prohibit the sale of the entire product that is specified as product name. This is a principle. So the infringed part is small is the issue of whether or not the defense of abuse of right is successful or not. Thank you.
예, 예, 답변 감사드립니다. 그러면 이어서 한국의 이경은 판사님 발표 부탁드리겠습니다.
네, 전체 제품의 일부만이 특허 침해에 해당하는 경우에는 해당 구성이나 부품만 금지 및 폐기 대상으로 하는 것이 원칙인 것으로 보이고, 주된 판단 기준은 그 특허권 침해하는 일부 구성이나 부품이 전체 제품과 분리 가능한지, 그다음에 불가분적으로 결합되어 있는지, 또는 별개로 거래되는지, 이 정도인 것 같습니다. 제가 자료집에 2개 판결을 소개를 해놨는데요. 그 중에 이제 첫 번째 특허법원 판결에 대해서만 이 자리에서 말씀드리고 싶습니다. 2016-1745 판결이고요. 이 사건 같은 경우에는 모터 체결 기구에 관한 특허권 침해가 문제된 사안입니다. 그래서 원고는 모터 체결 기구가 사용된 RC 감속기라는 제품 전체의 생산 금지 및 폐기를 구했는데, 이 판결에서는 이제 이 둘이 불가분적으로 결합되어 있는지 일체화되어 있는지를 기준으로 삼아서 일부분인 모터 체결 기구와 그 생산에 제공된 설비 제거 청구만을 인용했습니다. 근데 제가 이 판결에서 이제 조금 재미있게 본 부분은요, 제가 판시 부분을 자료집에는 인용을 해놨는데, 금지 대상의 범위와 관련해서 비례성 원칙을 언급하고 있다는 점입니다. 그래서 앞서 금지명령 발령 요건에서 봤듯이 한국은 금지명령 발령 여부와 관련해서는 어떤 비례성 원칙을 고려하고 있지는 않지만, 이 판결을 보면은 그 금지 대상이나 대상의 범위, 그 다음에 폐기의 범위와 관련해서는 비례성 원칙을 고려할 여지가 없는지, 또는 이미 고려하고 있는 건 아닌지, 이렇게 생각이 좀 고민을 하게 만드는 그런 판결인 것 같습니다. 예, 감사합니다.
예, 답변 감사합니다. 예, 드디어 마지막 공통 질문 2-3입니다. 예, 드디어 마지막 질문에 도달을 했는데요. 예, 공통 질문 2-3도 세부 질문을 통합을 해서 질문을 드리도록 하겠습니다. 먼저 금지 명령의 실효적인 집행을 위해서 귀국에서 채택하고 있는 구제 조치들과 그 집행 절차들에 대해서 간략히 소개를 해주시고 이와 관련하여 귀국에서 다소라도 광범위한 금지명령의 발령이 가능한 경우에는 집행 절차에서 피고의 판매 제품이 침해 제품으로서 집행 대상이 되는지 여부에 관한 판단이 누구에 의해서 어떻게 이루어지는지에 대해서 설명을 해주시고 또 마지막으로 침해 금지 명령이 내려진 이후에 피고가 침해 제품의 구성이나 내용을 일부 변경하였으나 여전히 해당 특허권을 침해하는 것으로 보이는 경우에 특허권자로서는 피고의 변경된 제품이나 행위에 대해서 기존의 침해 금지 명령에 기한 구제 조치를 할 수 있는지 아니면 별개의 침해 금지 청구의소를 제기해야 하는지에 대해서 각 국의 판단 기준이나 실무 사례가 있으면 소개해 주시기 바랍니다. 답변도 세부 질문을 통합해서 2분 30초 이내로 해주시면 감사하겠습니다. 먼저 미국의 최행 판사님 답변 부탁드리겠습니다.
Yeah, if a party violates an injunction, then we do have, as federal district judges, substantial discretion in imposing penalties and trying to coerce compliance. I can impose monetary sanctions, can require the defendant to disgorge any profit that they have made from the violation of the injunction. And if I really need to, I can order the United States Marshals, the federal law enforcement agents, to seize inventory. I was very tempted in one case to do that, ultimately decided not to. But if a defendant is untrustworthy and you do not believe that the inventory has been returned or will not be distributed, then we do have that authority as well. And I think when I find a defendant in contempt of an injunction, that also does create very serious reputational harm. Companies are very, very concerned when a federal court holds them in contempt. And thankfully, we still have the credibility as a federal judiciary that when someone clearly and knowingly has violated a court order, that is taken very serious by the business community as well. That their vendors and others will treat them differently. With regard to, we do not have the broad injunctions, but if in deciding whether or not a product is not more than colorably different, it's the same judge who issued the injunction who decides that. It's not a different judge or a different case. But if there have been enough changes that it is now more than colorably different, but we don't know whether it infringes, that's a new case. That is not going to be part of a case that has already been resolved at a permanent injunction. However, the patent owner can ask for the case to be reassigned to the same judge who issued the first injunction, and in that way, the judge will already be familiar with the law and the parties. Thank you.
예, 답변 감사드립니다. 그럼 이어서 영국의 헤이콘 판사님, 답변 부탁드리겠습니다.
The system in England is broadly similar. A court doesn't monitor its own injunctions. What happens is the plaintiff rather, alleges that the defendant is still infringing and is in breach of the court order, and then can make an application to the court for what we also call contempt of court. You're in breach of the order. And if that's established, usually the first sanction is to fine the defendant company. If they carry on or they repeat it, then the sanction can escalate to committing directors of the company to prison, or if it's an individual defendant, to commit him or her to prison. It very rarely happens, and the reason is usually in patent cases the companies are well established, and for reasons that mentioned by Judge Chang, they don't like a finding of contempt made against them. So this isn't very usual. If the issue on the contempt proceedings is rather like my Model X and Model Y example, the defendant comes back and says, well, you gave a judgment about Model X, and of course we're not in contempt because we're now selling Model Y. Well, it will turn on the issues I mentioned earlier. If Model Y contains all the essential features of the product found to infringe, that will be a contempt of court or only a minor colorable difference. if in effect the judge cannot decide whether Model Y infringes without a whole new trial, then that will be a separate matter and certainly won't be an immediate contempt. It will require a whole new trial to investigate it, and then that will have to be arranged separately. But otherwise, that's the way we go forward.
예, 답변 감사합니다. 자, 그럼 이어서 독일의 클라인 판사님 발표 부탁드리겠습니다.
Thank you. So a lot has been said already that I can rely on. In case of non-compliance, the court has the discretion to fine the defendant, and in extreme cases, there's also the possibility of detaining the legal representatives of the defendant. Now, it's the court of first instance who is responsible for those orders, so ideally this means that we will have the same judges again. Not in all cases, depending on the timeline that has been passed between the first decision and then coercive measures, but in many cases you will have the same judges who already know the case deciding this order. Now, in cases of broad decisions or broad tenors, we will usually be able to look into the decisions. So, for instance, if a certain standard was at the core of debate between the parties, then we will look into the attacked embodiment that is now in debate between the parties, and we'll find out if it uses a certain standard. We will not issue an order in enforcement cases without hearing the defendant first. So if there's any facts that are debated between the parties, we will get to know about this because we have at least a written procedure between the parties. Now, if there are alterations made, sometimes there's a very slim distinction. The idea is that if you can only read the first decision or reread the first decision, and then decide if the newly attacked embodiment with slight alterations still falls within the scope of the injunction, then you will be able to decide this case with just coercive measures. So really you can kind of rely on products that are essentially alike to also fall within the scope of the first injunction order. But if you have to go back to the patent, if you have to go back to claim construction, maybe discuss the same feature from another aspect, then you will have to file a new suit as a plaintiff. For an example, I've referred to my written answers, and we had a couple of series of cases and a couple of years back where actually the plaintiff was not sure if it was a new injunction case or if it was merely coercive measures, so they filed both on the same day, if I'm correct. So really, sometimes this distinction is very hard to make, even for professionals. Thank you.
예, 답변 감사드립니다. 이어서 일본의 시바타 판사님 발표 부탁드리겠습니다.
If the defendant fails to comply with the court's injunctive order, the court may order the defendant to pay to the plaintiff money of a certain amount that is found to be reasonable for securing performance of the obligation. That is a principle. And judgment ordering the destruction of product can be enforced by so-called substitute execution. Substitute execution is based on the authorization decision by the court. If no executor is specified in the authorization decision, the obligee or any other person may remove the infringing material at the debtor's expense. And so, as I said, Model X and Model Y cases, in Japan, I think it is necessary to file a new lawsuit. But a patentee can file a petition for a preliminary injunction, and a preliminary injunction would be issued quickly if it is proven that the modified product is not different in terms of the technical scope from the old product. Thank you.
예, 답변 감사합니다. 이제 마지막으로 한국의 이경은 판사님 발표를 부탁드릴 텐데요. 근데 우리가 그 저녁 마지막 세션에 예정된 시간을 이미 5분 정도 초과를 했습니다. 물론 저희가 5분 늦게 시작을 했지만 그래서 아까 우리가 이 세션에서 배웠듯이 금지명령도 공공의 이익에 의해서 제한될 수 있는데 공공의 이익을 위해서 답변 시간을 한 2분 정도로 좀 줄여서 간략하게 말씀해 주시면 감사하겠습니다.
네, 노력해 보겠습니다. 한국에서의 금지명령 집행은 민사소송 일반 집행 절차에 따라 이루어집니다. 그래서 특허권 침해 금지명령의 실효성 확보를 위해서 뭐 별도의 제도가 마련되어 있지는 않습니다. 그래서 뭐 금지명령은 부작의 의무를 명한 것이기 때문에 간접강제 방식에 의하게 되고요. 그래서 1일 얼마를 지급하라 뭐 이런 식으로 이행강제금 지급을 명하는 형식이 됩니다. 그리고 금지명령하고 함께 발령된 폐기명령 같은 경우에는 대체적 자기 의무이기 때문에 집행관에 의한 대체 집행이 가능한데 뭐 제품이나 생산 설비의 소재지를 주문하고 금지명령의 주문과 바꾸거나 뭐 하는 경우에는 그 집행이 어렵게 됩니다. 그리고 금지명령 발령 이후에 새로운 위반 행위를 제조한 제품 같은 경우에는 이제 이 대체 집행이 그 집행관에 의해서 이루어지기 때문에 그 대상 여부 판단이 어려울 것으로 좀 예상이 됩니다. 그리고 한국 실무에서는 구체적으로 특정된 피고의 침해 제품 외에 이와 유사한 제품 과 같은 형식의 금지 명령은 허용되지 않는 것으로 알고 있고요. 그 다음에 피고가 회피 설계를 통해서 그 구성이나 방법 일부를 변경한 경우에도 특허권자는 별도의 침해 금지 소송을 통해서 금지 명령을 받아야 합니다. 네, 2분이 안 된 것 같습니다. 이상입니다.
예, 이경원 판사님 특별히 감사드리겠습니다. 예, 이것으로 이번 세션의 모든 주제에 관한 논의를 마쳤습니다. 예, 시간 플로어에서 질문을 받고 싶긴 한데요. 예, 그 시간이 많이 지난 관계로 플로어 질문은 생략을 하고요. 혹시 간단하게 시간이 된다면 발표자들께서 추가로 하고 싶은 말씀이나 인사말을 짧게 해주시면 감사하겠습니다. 한 30초에서 1분 정도. 먼저 최행 판사님 혹시 뭐 간단한 말씀이나 인사 말씀 하실 게 있으시면 하시고.
Thank you. I just appreciate the chance to learn more about other nations and how they approach injunctions. I think in American law, because injunctions govern conduct going forward, it's not compensating for something that was done, as a historical fact. Judges in America, we do not want to legislate from the bench, and that sounds a lot like legislation. When you issue an injunction governing conduct going forward into the future. So I very much appreciate the chance to learn. Thanks.
이어서 헤이콘 판사님 간단한 말씀 부탁드리겠습니다.
Thank you very much. Well, as I think quite often happens when you hear views from different jurisdictions, although the detail of the approach may vary from one country to another, the similarities are much more striking than the differences, and well, that's encouraging. And I think it's explicable because we're all aiming at the same broad end to achieve a just result. So it's not only encouraging, I think it's quite striking that on the whole, the answers we gave were broadly similar.
이어서 클라인 판사님 말씀 부탁드리겠습니다.
I totally agree with HACON. This is what I kind of expected, but still it's very interesting to see how much we really come to the same conclusion in the end, even if we sometimes take slightly different ways. Thank you.
감사합니다. 시바탄 판사님 혹시 말씀.
Yes, the very different approaches, but same conclusions. It's very interesting. Thank you.
감사드립니다. 이어서 권범 판사님부터 순서대로.
Yeah, it was a great honor to participate in this meaningful discussion, and it was also interesting to find out how different the level of specification were among the countries. And let's have our delicious dinner together. Thank you.
이경원 판사님 간단한 말씀 부탁드립니다.
네, 앞에서 보니까 이제 여기 계신 분들이 정말 힘들고 졸리고 배고프고 하실 텐데 정말 뭐 자세도 바꾸시면서 여러 가지로 끝까지 경청하기 위해서 노력하시는 모습들이 다 너무 잘 보여서 되게 재밌으면서도 정말 감사한 마음이 들었습니다. 그리고 발표 들으신 분들 느끼셨겠지만 한국 같은 경우에는 뭐 기판력의 범위나 집행 가능성에 초점을 둔 나머지 이제 좀 그 금지 명령의 효력이나 범위가 굉장히 좁게 이제 발령이 되는 경향이 있는데요. 오늘의 이런 비교법적인 검토가 정말 우리 실무에도 시사하는 점이 많다고 생각이 됩니다. 네, 발표해 주시고 그다음에 경청해 주셔서 정말 감사합니다.
예, 이상으로 4세션을 마치겠습니다. 경청해 주셔서 감사합니다.
네, 감사합니다. 4세션 참가자들 수고하셨습니다. 이것으로 2023 국제특허법원 컨퍼런스 1일차 일정을 모두 마치겠습니다. 정말 수고하셨습니다. 공지사항이 있습니다. 잘 들어주시기 바랍니다. 2일차 일정은 내일 오전 10시부터 특허법원 청사에서 진행됩니다. 잊지 마시기 바랍니다. 그리고 오늘 태블릿을 받으셨을 텐데요. 떠나시기 전에 태블릿과 통역기는 자리에 두고 가시면 감사하겠습니다. 그리고 공식 만찬 참석자분들께 알려드립니다. 만찬 때는 좌석 배치가 변경이 될 예정입니다. 만찬 참석자분들께서는 통역기와 태블릿을 테이블에 두신 후에 개인 소지품은 모두 들고 로비에서 기다려주시면 감사하겠습니다. 만찬은 6시 50분에 시작하겠습니다. 자리가 변경되기 때문에 만찬에 참석하실 때는 안내를 받으시거나 배치표를 확인해 주시면 감사하겠습니다. 네, 모두 수고하셨습니다. 감사합니다.